Okay, we're going to get started. Welcome and thank you for joining us for this monthly SulmeyerKupetz webinar. My name is Hami. I'm here with Jessica Vogel. We are both attorneys at SulmeyerKupetz, which is a boutique firm in downtown Los Angeles specializing in all bankruptcy and insolvency related matters. Although we also have a small but quickly growing litigation and transactional practice. So as you can see on the screen, the title for this webinar is Staying Clear of the Automatic Stay. As that title was intended to convey, this webinar is going to address the bankruptcy automatic stay. The automatic stay is governed by Section 362 of the Bankruptcy Code, and it comprises one of the largest bodies of law in the bankruptcy context. So we're not nearly going to cover everything about the automatic stay. And we really designed this webinar more for non-bankruptcy attorneys to be sort of a primer on some of the major automatic stay concepts. Before getting into all the details, as a brief overview of what we're going to cover, we're generally going to cover the following areas. We're going to talk about first the scope and purpose of the automatic stay. We'll talk about next the duration of the stay, discussing when it goes into effect and for how long. Third, we're going to talk about issues relating to violations of the automatic stay. Fourth, we'll discuss how to obtain relief from the automatic stay and other issues relating to termination of the stay. And finally, at the end, we'll also address some of the more common scenarios that I think non-bankruptcy lawyers generally find themselves when the automatic stay hits them. Now, before getting into the main substance of the webinar, we should probably start by explaining what the automatic stay is, its scope, and its underlying purpose. So first, the automatic stay is really exactly that. It's a stay just like any standard injunction, and it's automatic, which means it's self-effectuating. It goes into effect on its own. You don't need any court order or any other type of judicial decree. The scope of the stay, which means the range of actions that it stays, is extremely broad. It almost literally blocks any actions taken against the debtor, against the debtor's property, or against property of the bankruptcy estate. And as we'll get into a bit more later, there are some statutory exceptions, but those are narrowly construed, whereas in contrast, the application of the stay to particular actions is broadly construed. And what this means is that if you're about to do something that you think may violate the stay, you should always err on the side that the stay applies, because, as we'll discuss later, a violation of the stay is a pretty serious offense. In fact, actually, a violation of the stay is severe enough that, at least in this district, the Central District of California, parties are permitted to file a motion to obtain what's called a comfort order to confirm that the automatic stay is not in effect. In essence, you're permitted to seek an advisory opinion regarding the automatic stay from the bankruptcy court. Now, to understand why this stay is so broad, it's important to understand the purpose of the stay. So a bankruptcy case really needs to be viewed as a collective proceeding. It involves many parties that are all vying for a piece of usually a very small pot of money. There's one debtor who usually owes money to a lot of different creditors, and the debtor only has limited funds to pay those claims. Also, as often is the case, the debtor usually is facing aggressive creditors, it's usually cash-strapped, or has some other financial problems that forced it into bankruptcy in the first place. So with those common circumstances, the automatic stay was designed to serve two primary purposes, and designed to protect both the debtor and the debtor's creditors. So first, it's designed to protect the debtor by giving the debtor a breathing spell from debt collection so it could reorganize or to otherwise address its problems, to obtain control over its property, and to otherwise facilitate an orderly reorganization or, if necessary, liquidation. In essence, the stay essentially says that everything has to stop to allow the debtor to get a grip on things and so it could try to fix its financial issues. The second primary purpose is it's designed to protect creditors by eliminating the creditor's race to seize the debtor's assets. Because again, as I indicated, there usually are limited assets or funds to pay claims, and the bankruptcy code has a priority scheme for the payment of claims. So staying collection activity protects creditors by ensuring that the limited funds available to pay claims are paid according to the bankruptcy code's payment scheme. Now, those are the two main reasons underlying the automatic stay, but there also is an ancillary purpose that comes into play, particularly in Chapter 7 bankruptcy cases, where you have an independent Chapter 7 trustee that's appointed to administer the case and to monetize the debtor's assets. The Chapter 7 trustee needs time to understand the case, get a handle on the universe of assets available, the types of assets, and the automatic stay is designed so to give the trustee some time so it's not distracted by having to deal with lawsuits or creditors trying to grab assets. So what in particular does the automatic stay stop? So as I indicated earlier, the stay is governed by Section 362 of the Bankruptcy Code, and in Section 362A of the Bankruptcy Code, it provides a pretty comprehensive list of categories of actions that fall within the scope of the stay. And many of those categories are identified over the next few slides. And again, it's a pretty broad categories of actions, and just a few examples would include the commencement or continuation of any judicial proceedings against the debtor, the enforcement of any pre-bankruptcy judgments or claims against the debtor or against property of the estate. It would block acts to obtain possession of property of the estate or of property from the estate, or to exercise control over property of the estate. And actually that one has very extensive implications, because control over property of the estate really could include almost anything. It includes direct and indirect control, and in fact some courts have even held that this would preclude for example, a county from changing zoning laws if those changes would impact property of the estate. And another example includes, or another category rather, any act to create, perfect, or enforce any liens against property of the estate. I just skipped through a few of the slides. Those slides I just skipped through itemize the different categories listed in Section 362A. Now, just to put those categories into more familiar terms, the stay would bar the filing or continuation of a lawsuit to collect on a claim that arose before the bankruptcy case was filed. It would bar foreclosures on the debtor's property. It would stop any judgment enforcement or collection practices, and actually even would bar terminating a contract on account of a pre-petition default, even when the contract otherwise would have allowed the contract to be terminated under the particular circumstances. Now, a few things to note before we get into the exceptions to the automatic stay. I just went through categories of actions that are barred by the stay. We're next going to move to exceptions, but before we get to exceptions to the stay, just a few things to note. First, all the actions identified that violate the stay only apply when those actions are taken against the debtor, the estate, or their property. And property of the estate is defined very broadly to include all property of the debtor, wherever it's located and by whomever held. And it practically includes almost any imaginable legal or equitable interest. Second thing to note is the automatic stay also prohibits the debtor, not just creditors, from taking actions that fall within the scope of the stay. So what that means, for example, if the debtor is, let's say, defendant in a pending pre-bankruptcy lawsuit, so that lawsuit obviously would be stayed once the bankruptcy case is filed, but not only would the non-debtor plaintiff be barred from proceeding with the action or taking actions within the context of that lawsuit, but the debtor, defendant, also would not be permitted to take any more action in that lawsuit so long as the stay is in place. The final thing to note before moving into the express exceptions to the stay, there are two kind of negative implications that you could take from the fact that the automatic stay protects actions against the debtor, its property, and property of the estate. The first, and this kind of is a segue into the exceptions. These are not expressly listed in the statute as exceptions, but again, through negative inferences, we can know that first, the stay does not apply to lawsuits filed by the debtor. So again, it only applies to actions taken against the debtor or lawsuits filed against the debtor, but it does not apply to lawsuits that the debtor filed. Those actions could proceed despite the bankruptcy, although often, as I'll discuss later, they often, in fact, are stayed. Second negative inference to take is the stay does not protect non-debtors or non-debtor, non-estate property, even if that non-debtor has some close connection to the debtor. One common example is guarantors. So people often guarantee the debts of their corporations, and then when their corporation goes under or is hit with financial difficulties, they look to put the corporation into bankruptcy. That's when I have to tell the principal of the corporation that just because their corporation files bankruptcy does not mean that they personally will be protected from the automatic stay from creditors seeking to enforce the personal guarantee. That being said, however, under limited circumstances, upon request of the bankruptcy court or to the bankruptcy court, the court could still impose a judicial stay against actions against the particular non-debtor if the circumstances warranted. An example would be, for example, such as to stay litigation against a debtor's principal if the principal is very critical to the debtor's reorganization, and if ongoing litigation against the principal would distract him or her or negatively impact the bankruptcy case somehow, or if enforcement of the guarantee would have some detrimental impact on the corporate debtor's reorganization, you could apply to the bankruptcy court to have the stay also apply to the non-debtor principal. Excuse me. Now, although the automatic stay, as you've indicated, is quite broad, it's not all-encompassing. It does have its limitations. So we just talked about a few of the limitations based on some negative inferences, but there are other exceptions. First, there are 28 categories of explicit statutory limitations that are set forth in Section 362B of the Bankruptcy Code. And we have only a few of them identified on the slide, or on slide 10, which include, for example, criminal proceedings against the debtor. Those will not be stayed. Certain actions relating to divorce proceedings, custody, domestic support obligations. Third, certain governmental actions, or what's usually referred to as a government's police power. Fourth, the stay would not bar acts to evict a tenant under a commercial lease that expired by the stated terms of the lease before the bankruptcy case was filed. And another exception is the eviction of a debtor-tenant from residential property if a judgment for possession was issued prior to the bankruptcy filing. Another situation sometimes accepted from the stay relates to the debtor's possession of property. In a relatively recent Ninth Circuit case, it's cited on the slide on the screen, the Eden Place versus Pearl. The court found that a debtor's naked bare possessory interest in real property under the facts at issue was not covered by the stay. In that case, which was published earlier this year, the court ruled that the automatic stay did not apply to an action to evict a former owner of real property when, before the bankruptcy case was filed, the creditor obtained an unlawful detainer judgment and an order for possession from the state court. Before this opinion came out from the Ninth Circuit, many courts, including courts within the Ninth Circuit, held that the automatic stay would have protected debtor's bare possessory interest in the rear property, even though the creditor had already obtained a judgment for possession. It should be noted, however, that the stay still would protect a debtor's possession of property if, for example, despite a pre-bankruptcy foreclosure or pre-bankruptcy termination of a lease, the debtor still had some type of state law right to redeem the property. Or, for example, in California, if a lease terminated before the bankruptcy case was filed, but the debtor-tenant still had a right to seek relief from forfeiture of the lease, if the debtor had that type of state law right going into the bankruptcy case, then the automatic stay would bar any acts to evict the debtor in that situation. In my view, however, all these exceptions, even the clear statutory ones, really are not helpful that much from a practical perspective. It's pretty rare that the situation is so clear-cut a case that you know for sure that the stay does not apply, and you really always take the risk of being found to be in violation of the stay. Therefore, it really would be prudent that even if you believe the stay does not apply for whatever reason, to still seek a comfort order from the bankruptcy court or to seek relief from the automatic stay out of an abundance of caution. All right, two final points regarding the scope of the stay before I move on to the duration of the automatic stay. First, the stay does not apply to acts taken to enforce a post-petition claim or a claim that arose after the bankruptcy case was filed. So, for example, if a party entered into a contract with a debtor after the debtor filed bankruptcy, and the debtor then breached that contract, the stay would not bar the other party to the contract's filing of an action for breach of that contract, because in that situation, the default and the breach occurred post-petition after the bankruptcy case was filed. The second point to note is the stay also generally does not apply to actions taken in the bankruptcy court itself. So what this means is that if a creditor files a lawsuit in the bankruptcy court within the bankruptcy case to enforce even a pre-bankruptcy claim, not a post-petition claim or post-bankruptcy claim, but a pre-bankruptcy claim, that would not be a violation of the stay, and that's even if filing the same exact lawsuit in state court or some other non-bankruptcy form would, in fact, be a violation of the stay. All right, so that covers the categories that are covered by the stay and exceptions to the stay. Now we're going to move on to the duration of the stay. We're going to discuss when it goes into effect and for how long. So in terms of when the stay goes into effect, the answer is it's the second the bankruptcy petition is filed. And now this would be the case whether the bankruptcy case is a voluntary bankruptcy or an involuntary bankruptcy. So once the petition is filed, the stay is immediately effective. And the exact time is pretty important, as we'll discuss more later, because an act taken in violation of the stay has absolutely no legal effect. As an example, if a foreclosure sale of the debtor's property, let's say, is set to take place at 8 a.m. on a given morning, if the bankruptcy case is filed at 7:59 a.m., literally, the foreclosure sale would be ineffective if it proceeded after the petition was filed. On the other hand, if the bankruptcy was filed at 8:01 a.m., when the gavel already hit and the property was sold at 8 a.m., the sale would be valid and would not have been barred by the automatic stay. Of course, it also is important to know exactly when the stay goes into effect, because you don't want to get caught violating the stay, as Jessica will discuss a bit later in this webinar. So now, how long does the stay last? So it lasts for a while, but it's not forever, obviously. Its duration really depends on the particular types of actions that are taken or that want to be taken. So first, with respect to actions against property of the estate, of the bankruptcy estate, the stay continues until either the property is no longer property of the estate. So, for example, when the trustee, the bankruptcy trustee, sells property to a non-debtor, and now the property is removed from the bankruptcy case, or the automatic stay no longer applies as the property of the estate if the court modifies the stay. However, with respect to any other action, the stay continues until one of three periods of time, or the earliest of 3 periods of time. First, the case is dismissed, the bank's case is dismissed, or the case is closed, or the time the debtor either receives or is denied it's his or her discharge. Now, the reason the stay terminates when the debtor gets his discharge is because the stay, in essence, is really just replaced by the discharge injunction, which is a permanent injunction against the collection of pre-petition debts or the debts that fall within the scope of discharge. Now, the duration of the stay also is impacted by the number of times a particular debtor files bankruptcy. So in 2005, Congress significantly reworked the bankruptcy code. And among the changes to the bankruptcy code in 2005 were provisions that were added designed to deter repeat bankruptcy filers from bad faith serial filings designed to always have the stay apply. So they'll file a case, stay goes into effect, then they have the case dismissed, and then when the creditor starts acting up again, they'll file bankruptcy again to just keep the automatic stay in place. So Congress added new provisions to Section 362 of the Bankruptcy Code that generally provides, first, if the debtor had one prior bankruptcy case within the past year as the present bankruptcy case, the stay would automatically terminate on its own within 30 days. The court could extend the stay upon request, but if no request to extend the stay is made or the court denies the request, then the stay automatically terminates in 30 days. So in essence, it flips the burden onto the debtor to maintain the stay rather than the other way around to have the creditor lift the stay. The second provision that was added to the Bankruptcy Code in 2005 was that if the debtor had 2 prior cases in the past year, then the stay doesn't go into effect at all. Obviously, it's 2 or more prior cases. The stay would not go into effect at all, and again, that could be changed upon request of the court. But again, the burden would be on the debtor or whichever party would seek to have the stay imposed to get that order from the bankruptcy court to extend the stay. All right, 2 more things before moving on to stay violations, where I'll turn this over to Jessica. So oftentimes, you'll see certain pre-bankruptcy contracts that include provisions under which a party agrees to waive the protections of the automatic stay in the event that the party files bankruptcy. And sometimes you also see situations where after the bankruptcy case is filed, there's a stipulation between a limited number of parties to have the stay lifted. The issue becomes whether these types of agreements are valid, the pre-bankruptcy waiver agreements or the post-petition stipulations. Are they valid to remove the protections of the stay? So regarding pre-bankruptcy or pre-petition waivers of the automatic stay, they generally are not enforceable. You usually see these types of provisions in secured loan agreements where the borrower purports to waive the protections of the automatic stay in the event the borrower files bankruptcy. And those are generally held not to be enforceable for 2 main reasons. One, it violates public policy. The policy for filing bankruptcy, one of the main reasons for filing bankruptcy is to obtain the protections of the automatic stay, have strong public policy underpinnings. So these pre-bankruptcy waivers are generally viewed as against public policy. And the second reason they're usually not enforced is, again, as I indicated earlier, the stay is designed not just to protect the debtor, in this case would be the borrower, which is the only other party aside from the lender to sign this pre-bankruptcy waiver. It's designed to protect all creditors, and those creditors are not party to this pre-petition contract, so the bankruptcy courts are not inclined to enforce those waivers. Finally, with respect to the post-petition stipulations that are filed after the bankruptcy case, you usually will see those stipulations between, for example, the debtor or the trustee and a single creditor. And those really are really not appropriate, because for the same reason that the stay is designed to protect other parties, not just the parties to the stipulation. And usually, again, these stipulations are just between the debtor or the trustee and then a single creditor. The other creditors are not parties to these stipulations as a general notion. However, I will say that if these stipulations, even if they're just between a limited number of parties, they are filed with the bankruptcy court, and if they are noticed to all the parties, to all the creditors, and all parties have an opportunity to object and be heard with respect to the stipulation, then those post-petition stipulations should be fine. We're now going to discuss, starting with violations of the automatic stay, which I will turn over to Jessica.
Okay, so now that you know what the automatic stay is and what type of actions it applies to, I'm going to explain what happens when a creditor violates the automatic stay, and then walk you through how to obtain relief from the automatic stay. One of the most important things we hope you take away from this webinar is that the consequences for violating the automatic stay can be costly, but with a better understanding of the scope of the automatic stay, it's relatively easy to avoid unintentional violations. So starting with the legal effect, as Asa touched on earlier, it's important to know that in the Ninth Circuit, any action taken in violation of the automatic stay is automatically deemed void and without effect, not merely voidable at the debtor's insistence. So to use the example that Asa used earlier in this webinar, this means, for example, that if a bankruptcy petition is filed at 8 o'clock in the morning and a foreclosure sale goes forward or a deed is recorded at 8:01 or any time after that, the bankruptcy court will treat the foreclosure sale, the recordation, or any other act occurring post-petition as if they simply did not occur and have no legal enforceability. And while this may seem harsh, as Asa explained earlier, there are important policy reasons behind immediately putting a stop to all creditor collection efforts, that Congress felt that this was an important implication, and the Ninth Circuit has confirmed the legal effect of the automatic stay. Now, in addition to losing the legal rights associated with the violating act, the violator will also have exposed him or herself to the potential for an action or motion brought by the debtor to recover any damages the debtor incurred as a result of or that are attributable to the violating act. Under Section 362K of the Bankruptcy Code, the standard for when a debtor may recover damages is set forth. And that section provides that an individual injured by any willful violation of the automatic stay shall recover actual damages, including costs and attorney's fees, and in appropriate cases may recover punitive damages. Therefore, if a court determines that a willful stay violation occurred, the debtor is automatically entitled to recover damages for the stay violation. And what's worse is that a willful act for purposes of Section 362K does not require any specific intent to violate the stay. In fact, all it is required is that the violator knew of the existence of the bankruptcy case, so that the stay was actually in place, and acted willfully. This means that ignorance as to what actions actually violate the stay will not relieve a creditor from liability under Section 362K. Now, practically speaking, depending on the level of sophistication of the violator, courts usually will take the violator's purported ignorance into account when determining whether to award punitive damages, but it doesn't relieve the violator from damages for actual damages resulting from their violation. So to give you an example of a willful violation of the automatic stay, in one case, a court found that a creditor's repossession of a debtor's vehicle one day after the debtor filed for bankruptcy, but without knowledge of the bankruptcy case, did not violate the automatic stay because there was no willful intent. However, the court held that once the creditor learned of the bankruptcy case and did not immediately return the vehicle to the debtor, the creditor then had willfully violated the automatic stay and was liable for damages. The takeaway here is to tread cautiously when a bankruptcy case has been filed, and if in doubt, do a little research or seek advice of a bankruptcy practitioner to avoid these unintentional violations. Especially since it does not appear as if the Ninth Circuit is likely to relax this approach on stay violations anytime soon, because just as recently as last year, in a case called America's Servicing Company versus Michelle Schwartz-Tallard, the Ninth Circuit overruled prior case law, which had actually limited the amount of damages a debtor could collect from a stay violation to only the debtor's actual damages. However, as a result of the Ninth Circuit's decision in Schwartz-Tallard, stay violators may now be subject to the full measure of a debtor's damages, including the cost of prosecuting the damages action, which, as any litigator knows, can be incredibly costly. Now, in addition to actual damages, punitive damages, and damages resulting from the prosecution of a stay violation, the Ninth Circuit has also held that a debtor can recover damages for emotional distress if he or she can present enough evidence to satisfy three factors. One, that the debtor suffered significant harm from the stay violation, and this has been interpreted to mean more than just some type of fleeting harm. Two, the debtor has evidence to establish that the harm suffered was significant, and this usually comes in the form of doctor's bills, proof of missed work days, or some other physical documentation of the harm. And three, that the harm has a causal connection to the violating act. So to give you an example, in the Dawson versus Washington Mutual Bank case cited in the slide, the debtors, a husband and wife, were able to recover emotional distress damages resulting from a bank's institution of an unlawful detainer action against them in violation of the automatic stay, following a lawful foreclosure sale on the debtor's residence. Now, despite the lawful foreclosure sale, the court noted that one of Congress's stated purposes for the automatic stay was to give debtors a breathing spell to put their finances back in order. Therefore, the Ninth Circuit concluded that Congress's inclusion of the term breathing spell suggested a human side to the bankruptcy process and determined that Congress must have been concerned about the emotional and physical toll that a violation of a stay could exact from an individual. As a result, debtors now can collect emotional distress damages from stay violations. Now, in addition to losing the legal enforceability of your act and being liable for potentially costly damages stemming from the violation, violators and their counsel can be found to be in civil contempt and be sanctioned depending upon how egregious the stay violation is. For example, in the Escanos and Adler case cited in your slides, the debtor filed bankruptcy and notified one of its creditors by mail of the filing. 5 days later, the creditor's attorney filed a state court collection action against the debtor on behalf of the creditor to collect upon a claim that arose pre-petition, so it would be stayed by the automatic stay. And the debtor made several post-petition attempts to speak with the attorney and left messages at the attorney's law firm to inform them of the bankruptcy filing. The debtor also sent faxes indicating the same. So there was plenty of effort on the debtor's part. And despite all of this, the law firm did not dismiss the lawsuit for a month. And made no effort to explain its delay to the court. In awarding sanctions against the debtor and counsel, the Ninth Circuit found that a party has an affirmative duty under Section 362A to discontinue post-petition collection actions in non-bankruptcy forms against the debtor. And therefore, the court held that the law firm had willfully violated the stay by maintaining the active collection action and unjustifiably delaying its dismissal despite repeated receipts of notice of bankruptcy filing. Now, there are a few exceptions to 362K's reach. First, Section 362K only applies to individuals. This means that corporate debtors are not entitled to seek damages for violations of the automatic stay. And courts have also interpreted this to mean that trustees may not pursue damages for stay violations as they are not considered an individual within the meaning of that section. Second, under Section 362K2, damages resulting from a stay violation will be limited to actual damages if a less common situation arises where, upon filing bankruptcy, the debtor has an obligation to file what's called, a Chapter 7 debtor has an obligation to file what's called a statement of intention, which basically requires them to set forth what their intention is for certain personal property, whether they're going to surrender or retain the personal property, and also applies to real property. And then for them to timely undertake whatever actions are necessary to perform what their stated intention is. So in a situation where, if the debtor fails to file the statement or follow through with the stated intention, then under 362H, the automatic stay automatically expires as to that collateral within 30 days. So 362K limits actual damages in a situation where you have a statement of intentions and a creditor believes that the 30 days expired on the automatic stay was lifted, and so in good faith they take actions that actually turn out to have violated the stay. And finally, in addition to the two exceptions I just mentioned, don't forget that Section 362B contains the list of exceptions to the automatic stay that don't involve stay violations in the first place, which Asa talked about a couple minutes ago. Now, another quasi-exception to the stay arises when a creditor violates the automatic stay but is not aware of the bankruptcy filing, likely because the debtor did not provide them with notice or list the creditor in his or her schedule. In such a case, a creditor may seek to annul the automatic stay to avoid the violating act from automatically being deemed void, and to also avoid damages, contempt, or sanctions. In order to have an act annulled, the creditor must file a motion for relief from stay under Section 362D, which I'll discuss in the next section. And in addition to providing proof that the creditor lacked knowledge of the bankruptcy case at the time it violated the stay, must demonstrate that cause exists to grant the annulment. Cause, for purposes of annulment, has been determined to exist where the stay harms the creditor, and lifting the stay will not unjustly harm the debtor or creditors. So a common example of this is the occurrence of a foreclosure sale or a recording of a deed after a pre-petition foreclosure sale, but the recording of closure, or the recording happens post-petition. In this situation, obtaining an order granting annulment of the void act will reinstate the legal effect of the act. And it's not limited just to pending cases either. So courts have retroactively annulled the automatic stay in prior dismissed bankruptcy cases where the courts have determined that circumstances warrant it. So if a creditor believes that they were not provided with notice of the automatic stay, then it's worth seeking or looking into whether annulment is a possible form of relief. Now, sorry. Okay. The procedure for filing a motion for relief from automatic stay. If a creditor believes it's entitled to relief, it can obtain stay relief by filing a motion under Section 362D of Bankruptcy Code, which initiates a contested matter rather than an adversary proceeding before the bankruptcy court under Federal Rule of Bankruptcy Procedure 9014. The motion must state the grounds for relief and should be accompanied by declarations, affidavits, or other evidence demonstrating that cause exists to grant relief. A party filing a motion seeking relief from the automatic stay should review Bankruptcy Rule 4001 and the court's specific local rules to confirm proper procedure. But what's good in this district, at least, is that the bankruptcy courts actually require the use of a form motion, which is designed to streamline the process and make it easy for non-attorney individuals to obtain relief from the automatic stay within a relatively short time frame and at minimal cost. Once you've got your form motion filled out and collected the evidence you'll need to file in support of your motion, it's time to actually file your motion. If filing the motion on regular notice, which is 21 days, a motion for relief from stay should be set out, self-calendared, 21 days from the date of the hearing, with oppositions to be filed 14 days before the hearing, and if an opposition is filed, replies would be due 7 days before the hearing. Courts in this district allow some motions for relief from stay to be set on shortened notice, which requires at least 7 days notice to interested parties. However, each judge has different rules for what type of motions qualify for shortened notice. So you should consult each judge's specific rules to determine whether you can file your motion on shortened notice or whether it needs to be brought on regular notice. And I should also mention that courts will also entertain requests for motion to be held on emergency notice, which is anything less than 7 days. So you should consult the local rules and specific judge procedures if you find yourself in need of an emergency hearing. Now, another important thing to note for any of these state court attorneys is that unlike in state court, where you often are prohibited from directly communicating with or serving the defendant, motions for relief from the automatic stay should be served on both the debtor and the debtor's counsel. If you fail to serve the debtor, your motion will likely be continued for another 21 days to allow time for you to properly serve the debtor, so it's in your interest to make sure that the debtor is properly served. In seeking relief from the automatic stay, Section 362G governs the burden of proof, and it provides that the movant has the burden of proof on the issue of whether the debtor has equity in the property, and the debtor has the burden on all other issues. So now let's talk about the grounds for obtaining relief from stay, which are listed in the slide and set forth in greater detail in Sections 362D1 through D4 of Bankruptcy Code. In applying Section 362D, a bankruptcy court has discretion to terminate, annul, or modify the automatic stay. So there's also the possibility that the bankruptcy court will determine that despite a creditor's good showing of cause to lift the stay, that the estate would actually be better served by leaving the stay in place and would accordingly deny the motion. Now, the first ground for obtaining relief from stay is for cause under Section 362D1. Cause is intentionally a broad and flexible concept designed to give bankruptcy courts flexibility to consider the facts of each case and to lift the stay where sufficient facts exist to warrant that the stay be lifted. However, common examples of cause under Section 362D1 include instances where a creditor can demonstrate a lack of adequate protection, bad faith, or the existence of an action in a non-bankruptcy forum. And I will discuss each of these in turn. First, under 362D1, relief from stay will be granted where a creditor can demonstrate that there is a lack of adequate protection of an interest that creditor has in property. Adequate protection is a term of art in bankruptcy, and it essentially requires that a creditor show that they are at risk of losing some or all of the value of their interest in identified collateral. So a creditor's ability to collect adequate protection turns upon their ability to submit evidence of the amount of the debt and the present value of the collateral. And the purpose of this is to determine the debtor's so-called equity cushion, which essentially involves plugging the fair market value, the creditor's debt against the property, and any other existing debt into a formula that determines how much of an equity cushion the debtor benefits from. And in the Ninth Circuit, if a debtor has greater than a 20% equity cushion in the property, the creditor will not be entitled to relief from stay or adequate protection payment. Other ways to show a lack of adequate protection include circumstances where the debtor is not maintaining insurance or the insurance policy is insufficient to protect the full value of the property, to show the debtor hasn't been paying state or federal taxes, that the bankruptcy filing was done in bad faith to just delay an inevitable foreclosure or repossession, that the officers and directors are mismanaging the property or allowing corporate waste, or that the debtor has had time to confirm a plan of reorganization and hasn't done so within a reasonable period of time. Now, if a court finds that a creditor's interest is not being adequately protected, the bankruptcy court can order any type of appropriate protection to address or remedy the risk to the creditor. Oftentimes, this results in a debtor being ordered to make periodic cash payments, excuse me, or offer a replacement lien on other valuable collateral. The purpose of adequate protection really is just to compensate creditors for any decrease in value of their collateral or perceived risk in decrease while the bankruptcy case is pending, but still allow the debtor to use the property to either benefit the debtor with its breathing spell, or if it's in a reorganization case, it may be necessary to allow the debtor to successfully reorganize its affairs. Okay, turning to bad faith. Evidence of bad faith provides another basis for establishing cause to lift the automatic stay under 362D1. Bad faith is sort of a nebulous concept, but it can be demonstrated by showing that the bankruptcy case involves a single asset partnership with no employees, no unsecured debt, and no true purpose of reorganizing, that the debtor's primary asset doesn't produce an income stream sufficient to service the outstanding debts on the property, that the debtor has continued to incur post-petition debts which it has no prospect of repaying through a plan of reorganization, and it's clear that the debtor is just taking advantage of the stay. If the case involves a two-party dispute more properly resolved outside of bankruptcy court or already pending in a different forum, and in the instance of serial bankruptcy filers. Actions in non-bankruptcy form. So another basis for relief under 362D1 exists where a creditor moves for relief from stay to allow a pending lawsuit or other administrative proceeding to continue in a form outside of bankruptcy. In the Central District, there's a separate form for motions seeking relief from stay for actions in non-bankruptcy forum, so you should consult that if that's the fact of your case. In the Ninth Circuit, courts consider a 12 non-exclusive factor test to determine whether to lift the stay to allow other proceedings to go forward, which include, but is not limited to, whether allowing the proceeding to go forward will interfere with the bankruptcy case, whether granting relief will allow complete resolution of the issues or if it will only provide partial resolution, whether the matter is in the later stages of litigation. Oftentimes these cases are ready for trial, and on the eve of trial, debtors will file for bankruptcy to prevent the trial from going forward. And courts also will consider judicial economy, prejudice to the parties, and whether there's an appropriate tribunal to hear the cause of action. So in my experience, courts are usually willing to allow actions to proceed in non-bankruptcy form to go forward, mostly because they don't want the issues brought before the bankruptcy court where they don't need to be or where there's already an appropriate forum established. But if the court determines that the non-bankruptcy litigation will result in a determination that impacts the bankruptcy estate or estate property, the courts are going to be less inclined to grant relief. Now, turning to the second ground for granting relief from stay under 362 is D2. And this involves finding that the debtor has no equity in the property or an insufficient equity cushion, and that the property is not necessary for the debtor's reorganization. To determine whether the debtor has equity, you just, again, subtract the total amount of encumbrances against the property from the property's fair market value. And in a Chapter 7 case, since the purpose of bankruptcy is to liquidate assets rather than reorganize, a creditor of a Chapter 7 debtor need only prove that there is an equity in the property to get relief from stay under 362D2. You may recall, though, that under Section 362G, creditors only have the burden of proof on the issues of equity anyway. So why make the distinction between 7 and 11? And the reason is that in reorganization cases, creditors will usually present some basic showing that their collateral is not necessary for the debtor's effective reorganization to force the debtor to then make a showing that the property at issue is essential to the debtor's ability to reorganize, and that there's a reasonable likelihood that the debtor will be able to successfully reorganize its affairs. So again, D2 turns on lack of equity and the importance the collateral really has in the reorganization process. Okay, Section 362D3 arises with single asset real estate cases. And this is a more nuanced ground for obtaining relief that involves what is known as a single asset real estate, which is defined as real property consisting of a single property or project other than a residential property with fewer than 4 units, which generates substantially all of the gross income of the debtor, on which no substantial business is being operated other than the real property. So think a commercial property where the debtor is renting and collecting rent and behind in their payments. The creditor is going to foreclose on the property. Debtor throws the case into bankruptcy. Save potentially equity and significant equity sometimes in the property. So if there is a single asset real estate case, the code provides that relief from stay must be granted unless within the later of 90 days after the petition date in a voluntary case, or 90 days after the later of a later date if the court determines, or 30 days after the court determines the debtor is subject to single asset real estate provisions, the debtor files a viable plan of reorganization, or the debtor commences monthly payments. So these types of cases usually involve two-party disputes, and the purpose is to address what was perceived as abuses, where debtors were merely attempting to delay foreclosure sales with no chance or little chance of reorganizing. And so the purpose of 362D3 and the automatic relief from stay after the prescribed time is that it forces debtors to react more quickly, otherwise the creditor benefits from relief from stay. Okay, the final ground for relief under Section 362 is D4, which requires a showing that the petition was part of a scheme to delay, hinder, or defraud creditors that involves either the transfer of all or part ownership of an interest in real property without the consent of the secured creditor or court approval, or to multiple bankruptcy filings affecting a real property. So this is one example of type of bad faith that will warrant relief under Section 362D1. The creditors often seek relief under both D1 and D4. But the purpose and benefit of also obtaining relief under D4 is that if a creditor establishes a basis for in rem relief, they will get an in rem order that they can then record with the county recorder's office in the county where the property sits, and that order becomes binding in any future bankruptcy case filed within 2 years after the in rem order is entered that would affect the real property. And the purpose of this is to prevent debtors from transferring fractional interests in property to multiple debtors or filing multiple cases where a creditor is left with an unending string of bankruptcy cases tying up their property. However, in my experience, even where creditors have obtained in rem orders, many practitioners will still seek comfort orders just to confirm that they're not violating the automatic stay and being subject to damages. And I should also note that if you represent a debtor, in rem relief doesn't leave a debtor entirely without recourse for the 2 years, because a debtor may seek relief from an in rem order in a subsequent bankruptcy case based on changed circumstances and for good cause shown. Okay, so now you know the basics on how to file a motion and what grounds to assert to obtain relief. So I'll just make one last point about obtaining relief from stay, and it relates to Section 362E. Now, although some courts frown upon a creditor racing in to obtain relief from stay, especially in reorganization cases where there's sufficient equity in the property, obtaining a relief from stay can be incredibly important and at times immediately necessary for a creditor facing substantial risk of harm as a result of the bankruptcy filing. So recognizing this, Congress included Section 362E, which essentially requires a court to conduct a prompt hearing on the issue, usually within 30 days from the date the motion is filed, unless the parties consent otherwise or the court articulates some compelling reasons to defer a ruling. This section's a little bit more detailed than that, but the general takeaway is that you can expect a relatively quick determination on the issue once the matter is brought before the court. Okay, and with that, I will turn the discussion back over to Asa to briefly finish us out.
Okay, thank you, Jessica. We'll conclude now the webinar with addressing some of the more common proceedings or actions that are impacted by the automatic stay, and in which I find that there sometimes is confusion for non-bankruptcy attorneys regarding the impact or application of the stay. So the first scenario we'll deal with is litigation. As I discussed earlier, excuse me, litigation pending at the time the bankruptcy case is filed is almost always impacted by the automatic stay. Now, oftentimes you are in the midst of a lawsuit or even perhaps on the eve of trial, only to discover that one of the litigants has filed bankruptcy. So what does that mean? What impact does that have? So a few things. First, as I indicated earlier, the action is only stayed to the extent the action was filed against the debtor and not by the debtor. However, it's important to note that even in an action filed by the debtor, which would not be stayed, the non-debtor defendant is allowed to take defensive actions against the debtor. So that means that you don't have to worry about violating the stay if, for example, you filed a motion to compel discovery against the debtor, a motion for summary judgment, or similar type of motion. Sometimes people think that you may not be able to take these actions, even though the case is not stayed. They may still think that their actions, defensive actions, are stayed. They're not. The second common situation in the context of litigation is an action that involves multiple defendants, only one of them being the debtor. In that case, the lawsuit would be stayed. It would also be stayed, but only as to the debtor defendant and not the other non-debtor defendants. So this means that the action would proceed, or could proceed at least, against the other defendants. However, in my experience, state courts are pretty hesitant to do anything in a lawsuit once they find out that one of the parties filed bankruptcy. They sort of get scared to touch it, and the state court generally just stays the entire action on their own. Or at a minimum, sometimes they'll ask for a briefing from the parties regarding the impact of the automatic stay. And even if the state court understands the intricacies of the automatic stay, it may very well stay the entire case anyways, even if only one of the parties in a multi-party action filed bankruptcy for purposes of efficiency. And this is especially true if the debtor is a primary defendant in a lawsuit, or a primary party, or somehow critical to the lawsuit such that it would really be silly to proceed as against the other parties while staying the action as to only the debtor. Finally, counterclaims. Suppose you're sued and the plaintiff files bankruptcy. So the action in that case would not be stayed, again, because that's a lawsuit filed by the debtor. But what if you had asserted counterclaims against the party who now is the debtor? So you were a defendant, and now you asserted counterclaims against the plaintiff who has filed bankruptcy. The question is, are those counterclaims stayed even though the initial lawsuit is not stayed, or the claims against you by the debtor is not stayed? So the answer is yes. If the counterclaims are asserted against the debtor, that aspect of the lawsuit is stayed. But again, like the case with multiple parties, depending on how intertwined the main claims and the counterclaims are, the state court may very well just stay the entire lawsuit, given that it a lot of times would be inefficient to allow only half an action to proceed. The next scenario that comes up relatively often are appellate proceedings. So in this case, suppose the underlying lawsuit is over, and before the case is filed, someone appeals. Now, one of the parties to that appeal files bankruptcy. So the issue becomes whether or not the appeal is stayed. So it depends. I mean, many people think that you would look to whether the debtor is the party who filed the appeal or if the appeal was filed by the non-debtor party. But that's not the case. An appeal, regardless of who initiated it, is simply viewed for the automatic stay purposes as really just an extension of the underlying lawsuit. It's not viewed as a standalone proceeding. So what you have to do in that situation is look to the underlying lawsuit and determine if the appeal is stayed or not. So if the debtor is the plaintiff in the underlying lawsuit, then the appeal is not stayed, and that's even if the non-debtor defendant was the one that initiated the appeal. If, on the other hand, if the debtor is the defendant in the underlying lawsuit, then the appeal is stayed, and that's even if the debtor defendant initiated the appeal. I mean, that's at least the rule in the Ninth Circuit. I'm not sure. There may be a split in other circuits, but that's how appeals are analyzed within the Ninth Circuit. The final type of proceeding that comes up quite often is when a bankruptcy is filed and the stay kicks in as against foreclosures. Foreclosures that are generally against the debtor's real property. So if the foreclosure sale relates to debtor's property or property of the estate, the foreclosure obviously would be stayed. But this is one of those times when, as I discussed earlier, the timing of the bankruptcy filing is absolutely critical because, again, if the hammer drops before the bankruptcy is filed, the sale would be valid. But if the bankruptcy is filed even 1 second before the foreclosure sale, the sale is stayed, and if it proceeds, notwithstanding the stay, the sale would be void, and you actually risk being sanctioned for violating the stay. It should be noted, however, that if the foreclosure sale occurs before the bankruptcy case is filed, although the sale is valid because, again, the sale occurred before the bankruptcy, the buyer at the foreclosure sale would have only 15 days to make sure that the trustee's deed is actually recorded. So if a non-judicial foreclosure sale occurs before the debtor files bankruptcy, but the purchaser does not record the trustee's deed prior to the bankruptcy filing, the purchaser has 15 days from the pre-petition sale to record the deed without violating the automatic stay. If the purchaser waits beyond this 15-day period, the post-petition recording of the trustee's deed would be a violation of the stay, and the purchaser's title to the property would be subject to avoidance by the debtor or the bankruptcy trustee. Now, one final point in respect of foreclosures or the application of stay as to property. There have been circumstances under which record title to real property is in one party's name, but a different party is a true beneficial owner of the property. So, for example, suppose a husband and a wife buy property together, but title is placed only in the husband's name. Now, years later, they divorce, and the wife is awarded the real property as her sole and separate property. For whatever reason, they neglect to execute or record a deed transferring title to the wife, and record title remains in the husband's name alone. Now let's say a lender with a lien against the property seeks to foreclose, and only the wife files bankruptcy. The lender would argue that the stay does not apply because record title is in the husband's name, and the husband did not file bankruptcy, only the wife did. The husband or the wife would contend that the wife is the true and only owner of the property, and because she filed bankruptcy, the stay protects this property and the foreclosure should stop. So who's right in that situation? Now, the wife should be right. If she truly is the beneficial owner of the property, the stay should apply to block the foreclosure, even though record title is in the husband's name. The husband really should be viewed as merely holding the property solely in trust for the wife, in which case the property would be property of the estate and subject to the stay. On a practical level, under these types of circumstances, where record title does not match actual beneficial ownership, if the creditor is aware of the discrepancy, it really behooves the creditor to postpone the foreclosure or postpone whatever action it's planning to take until the matter is cleared up, preferably through the bankruptcy court or through a comfort order or relief from stay motion. If you represent the debtor under such circumstances, you should consider obtaining an immediate order from the bankruptcy court finding that the automatic stay bars that foreclosure, or if not, at least imposing a judicial stay or an interim judicial stay until the matter is cleared up. That concludes the substantive portion of the webinar. As you probably picked up over the course of the webinar, or hopefully you have, the moral of the story really is that when in doubt, you should seek relief from the automatic stay or get some clarification from the bankruptcy court. It really would be, in the end, much cheaper than potential damages or sanctions that you risk if you violate the stay. Again, that concludes the webinar. Thank you for listening. If you have questions, this final slide includes my contact information and Jessica's. It also even includes our pictures, which does not do us justice. So feel free to reach out to us with any questions that you have. I see I have a question here from a Nick Cantor at Lewitt Hackman firm. Your question requires an in-depth answer. So Nick, if you could reach out to me after the webinar offline, and I'd be happy to discuss that with you. If anyone else has any questions, feel free to reach out to us offline. Thank you very much for listening, and we hope you enjoyed the webinar.